Good morning, students. Hope you all are fine and good. So the last class we saw about the about joint Hindu family system and about the partnership firm and how it is formed. So advantages, disadvantages. Then we saw about the different types of partnerships in a firm. And now the today topic is types of partnership. Let's move on to the topic types of partners. So what are the different types of partners that we have in a partnership firm? Let's go on. Okay, so the first one is active partner. Active partner are the partners who takes part in an active part in the conduct of the partnership business. So what he will do is he will participate into the partnership firm, and then he will do all the work in the firm. See, though every partner is entitled to manage its affairs, all may not do so. So everyone has to actively participate in the partnership firm. See, I already told you, when the partners are going to invest into the business, one may be silent partner also, the other may be one can say only I'm going to contribute the capital, but I'm not going to take part in the business and all that. Also that type of partnerships also are there. But active partner means a partner who is going to actively take part into the business. For everything he is going to be very active. That is what is called that is what the person is called as an active partner. Okay, the next partner that we have is a sleeping partner. So who is a sleeping partner? Sleeping partner means he will only contribute the capital, but he will not share. See, a partner contributes capital and shares in the profit and loss of the firm, but does not take part in the management of the business. He is going to contribute the capital. He will take the profit also, whatever is going to they are going to yield from the business, that everything he is going to get, but he will not take part in the management of the business. So he is called as a sleeping partner, because he is only going to invest into the business, but is not going to do what? Take part in the business. Okay, that is what the sleeping partner is, otherwise even called as dormant partner. The next one that we have is a nominal partner. Who is a nominal partner? This man is totally a different person. What he is not going to contribute the capital also, but is not going to do anything for the business also, but what he is going to do is he is going to just lend his name, okay, for the business. Let's see what it is. Such a partner neither contributes any capital nor is he entitled to manage the affairs of the business. He only lends his name to the firm because on the strength of his name and reputation, the firm may attract additional business and raise funds easily. A nominal partner, however, what he's going to do? He is liable for all the acts and debt of the firm. You know why? Because this man, what he's going to do, he is not going to contribute into the business, he is not going to take part of any kind of management also, but what he is going to do is he is going to just refer his friends. He is going to lend his name for the business, where he is going to just refer the people. Because of him, so many people are going to help for the liabilities, and even they are going to give business for them. So that is what the role of a nominal partner. Okay, so he is nowhere related with the business, only for with the reference he is going to help the business. Okay, that is what is nominal partner. Here what happens in case in future the creditor is going to give the money, okay, and if they are not going to get back the money after one particular time, what happens? This nominal partner is also liable for the credit whatever he has taken from the creditor. You understand? So whenever there is a debt, he is also liable for that with the other partners. Okay, though he does not get any shares in the firm's profit, but then to what he is liable for the liability of the partnership, because his name is being lended, right? Because of that, he has to answer for the liabilities. Next one, the next topic, the next partner that we have is partners in profit only. Yeah, the name itself we can understand. Yeah, he is going to participate only when there is a profit. When there is a loss, it means he will not get the loss at all. So let's see this. When a person joins a firm as a partner on the condition that he is entitled to be specified shares of the firm's profit only, he is called a partner in profit only. It means that he will not be called upon to bear any portion of the losses sustained. He will, however, be liable to third parties for all the debts of the firm like other partners. Such partners usually do not take part in the management of the business. Are you able to understand with this concept? See, it is very clearly mentioned here. The partners in profit only means what this man will do, like the other partners, he will also invest. Okay, but what he will say initially is, he will say, I will invest the money, but I am not going to do any kind of work in the business, in the partnership. But what I will do, I wanted to get 1% of profit every month. So every time I need to get one particular percentage of profit. So for example, one profit, say 1 lakh is a profit, I will get around say 60% of the profit. It means 60,000. So every time whenever the profit is equal, what he will do, from the total profit he will get around 60% of the profit, and then he will utilize this, he will take that as a profit for him. You understand? So not the whole profit is not, see, 1 lakh, for example 5 lakh, if it's the profit is there, and 5 people are going to share, 5 partners are going to share, it means divided by 5, it is 1 lakh. So 1 lakh, each partner is going to get the profit. But in this profit only partner, what he will say, I want only one particular percentage of the share whatever he is going to get. So what on with that 5 lakh, he will just say 1%. That percentage of amount will be given to him, not the full amount of his share. Say not 1 lakh. Okay, he will be getting according to his percentage 60,000 or 70,000 he will get instead of 1 lakh. So what happens is, the rest of the money will be shared by the other partners. So when there is a loss, this man will not bear the loss, others has to bear the loss. You understand? And the liability will be, of course, like a partnership firm, what it is, a joint and several liability. Everyone has to bear the liability. Everyone is liable over here, isn't it? It is unlimited. So they have to share. They have to share all the liabilities. They need to answer the creditors. So that is what the part here. But the next one, the next type of partner that we have is partner by estoffel. So who is a partner by estoffel? In case a person represents himself or herself by words or actions, or has allowed him to be represented as a partner of the firm, even though he is not a partner, he is called a partner by estoffel. You able to understand? See, a person is represented himself or himself by just a word. See, for example, 3 partners are going to talk. Okay, 3 people are going to stand in one place and they are going to talk. At that time, when the 4th person, he is not a partner into the business, but though what he is doing, he is just acting like a partner. When the others see, the outsiders, he pretends that he is a partner in the business. See, that is what it is given. So he makes the outsider to understand that he is a partner. He makes them to understand that he is a partner, because of his activity, others will think that he is also a partner in the business, and because of that, what they will do, they will give liability based on that particular person's goodwill. So what happens is, finally, when they come to, in this case, what happens, when they give the liability and if they are not able to repay it back, so this man is also liable for that particular the money whichever they get it from the partners. Okay, the next topic. The next partner that we have is, such a partner cannot deny his liability if outsider party lends money to the firm, supposing him to be a partner. So that is what. So this is what the partner by estoffel. Okay. So the next partner that we have is the partner by holding out. Who is a partner by holding out? When a person is declared as a particular, the person is declared as a partner and he does not deny this even after becoming aware of it, he becomes liable to the third party who lends money or credit to the firm on the basis of such a declaration. Partner by holding out, what is that? I already explained you one situation. See, 3 partners are there, one outsider is going to come there, and when he is going to talk to them, and I told you that the others will pretend that he is also a partner into the partnership business. So in this case, what happens, if someone is going to give money to them, okay, the creditor is going to give money to them by pretending that he is also a partner. But when he is told that he is, when this creditor comes to know that, when the creditor declares that he is also a partner, that time he should stop, and as soon as they know that he is a partner, he has to stop and he has to say, I am not a partner. That is what is called as partner by holding out. See, when a person is declared as a partner and he does not deny this even after becoming aware of it, he becomes liable to the third party who lends money or credit to the firm on the basis of such a declaration. Is it clear? So This is what the partner by holding out. Next one, secret partner. So who is a secret partner? A partner is one whose association is not known to the general public. So this kind of partner whose association, it means he is not known to the general public. He is not going to be known to the other people. He is also a partner. One secret person is there. He is also a partner in the business, but he is not known to outsiders. Okay. Other than this distinct feature, he is like rest of the partners in all respects. Okay, the only one thing, he is going to be a secret partner, but all other things are same. The liability will be it is the unlimited liability only. It will be joint and several. Then he has to bear all the debts if in case any in future, and whatever the profit ratio what they share, that everything is equal only. Okay, and taking part in the business, that everything is same only, but only this, that is he is going to be only a secret partner. He is not going to be known to outsiders. That is what the secret partner. Next one, minor partner. Minor partner, it's very clear. Minor means the people who are less than 18 years of age. The child who a person who does not attend the majority, then he is a minor partner. So see, only in this kind of business we have an option where we can even take in minor as a partner. Okay, see this, under the Indian Majority Act, person who has not completed 18 years of age is a minor. Yeah, I told you, isn't it? So when we don't reach the age of 18 years, then we are called as minors as per the Indian citizenship. Okay. So however, he will continue to be a minor until he completes the age of 21 years. The reason why, if he is, for example, a person is going to become a partner in a partnership firm. Okay, at the time of 17 years. Okay, see, 18 years is the time when he becomes a major, but though what he does, he is becoming a partner at the age of 17 itself. So there he is a minor, isn't it? So he has already become a partner at the age when he is minor, but though after becoming a major, after 18 years also, he has to wait till 21 years. See, once he enters into partnership, he has to wait. Even after he becomes a major, he has to wait still 21 years. However, he will continue to be a minor till he completes the years 21 years if a guardian has been appointed to the minor. So a guardian will be appointed in spite of him. So what will happen for him? For example, on behalf of him, a guardian is going to take the decision and take part all activities into the business. So until that, see, I already told you, 17 years a person is going to become a partner. So at that time, when if he is a minor, but 18 years he becomes major, even though he has started the partnership by 17 years, so he has to wait till 21 years. Already a guardian will be there for him to help for all other activities. Okay, so he can be admitted to the benefits of the partnership. So he can even he can enjoy the benefits of the partnership even though he is a minor. The next one that we have is what? The next, partnership arises as a result of contract, but a minor has no contractual capacity, though a partnership cannot be created with a minor as a partner. A minor can be admitted to the benefit of a partnership which is already in existence. The consent of all partners is a must for such admission. Is it clear? So if you want to make a minor also into a partnership firm, even like other cases, here also you must get the consent of other partners. Then only you can make even the minor as a partner. That is what is given here. Okay. The next one, registration of partnership. Yeah, this is one of the most important topic. So any business if you start, we have so many procedures, I told you, isn't it? You have so many, the laws are there which we have to follow, and according to the law, certain rules and regulations are being formed that we have to follow, and we have to strictly we have to stick to it. So now see, the Indian Partnership Act does not make the registration of the partnership compulsory. As I already told you, if you want to start a partnership firm, it is not required that you must register, or if you don't want to register, or if you don't want to make it as in a written way, even you can have it in a oral form. Okay, that is what, it is not compulsory at all. Registration is optional, but the disabilities of non-registration virtually makes it compulsory. Of course, you know very well. So every business, it is with the profit only. Without money, nothing is there, isn't it? So in case even if it is if the people are so loyal, at one particular stage what happens, they might even become disloyal also. So because of that only what happens, we must always, it is always better and safe to register a partnership firm, because if you register it, in any case if you have any kind of issue or disputes or anything, you can just go to the court of law. If you don't do that, you can't go and justify yourself. The next topic we have is a procedure for registration. So like how you want to register your firm, like what are the procedures, what are the details which is required when you want to register a partnership firm. Let's see what and all we need. A statement should be prepared stating the following particulars. For example, if you want to open a new account, okay, you'll go to bank, then you will get a KYC form and you will fill all the details, isn't it? Like same way, if you want to register your firm, you need for certain basic details should be given over there, like your name of your firm, what name you have selected for your firm, then who are the partners, the name of the partners, then how much principal amount you're going to start the business, then what kind of business you're going to do, and the date which the partner you are going to start your partnership, then the duration of the partnership. All these are the basic details which is required for a partnership. So these are the things which are given here. I will just read this. Okay, see, name of the firm, the principal place of the business, name of other places where the firms carried on the business, names and addresses of all the partners. Fifth one, the date on which each partner joined the firm. Sixth one, duration of the firm. So these are the basic information which are required to start the procedure for registering your partnership firm. So when you make an agreement, I showed you one format, right? One agreement format, one stamped the currency was there, isn't it? So that particular page you need to register with all this information. Then only a partnership will be a valid one. See, the statement signed by all the partners should be produced to the register of the firm along with the necessary registration fee. Can you see this? So one fee will be there for each partnership based on your business, based on your principal amount. You will have one registration fee charged by the registrar. So that you must pay. Okay, any change in the above particulars must be communicated to the registrar within 14 days of such alteration. If you have any changes with your partnership agreement, or any changes there in your address, or any kind of change in your principal or your business or type of business, what you want to do, all that, any changes is there, or if you want to extend your partnership firm, anything is there, you can just go back to your registrar within 14 days so that you can alter that and you can have it. Okay, so after that you can't do anything. After that you can't start your alteration. It will start to go for a work. The next one, drawbacks of non-registration of firm. What is drawbacks of non-registration of firm? So drawbacks means like when you don't register your partnership firm, what and all drawbacks, what and all demerits, what and all effects that you will face. Okay, no rights to file the suit against others. You know what is suit? Suit means case. Okay, so no rights to file suit against others. You can't file a case against others. If anyone is going to do any disharm, any dishonest or any kind of cheating or any fraudulent activities, you can't go and suit you can't file a case against that particular person. The reason is your partnership is not being registered. That is what the basic reason. See, an unregistered firm cannot file a suit to enforce its claim against third parties in such rights arises out of a contract. See, if you don't have a contract registered, what you can't do? You can't even raise a complaint against a person. That is what the first one. See, example, no court of action is possible to recover the debt from the third parties. It has no rights even to demand a set off in any suit filed by its creditors. Can you understand what it is? Set off means solving the problem. That is what. So you can't find any solution. If you go to a court also, if you don't register your partnership, it will not be a valid, it won't be considered as a valid one. That is what. So you won't be considered as a valid one, and it will be neglected by the court of law also. So the first one is what? You must register your firm. That is what. See, the next point is rights to sue for right arising. What is that? Rights to sue for right arising. If for someone is going to harm your organization, say someone is throwing a stone, or someone is putting fire accidentally, you have got a theft in your firm, something has happened, okay, this is the person who has done everything and he has done the thing, but you can't go to the court of law and say that this person has done all this, because your partnership has not been registered. That is one of the big drawback. There you will not be a valid case. You understand? However, it can sue others for enforcing rights arising otherwise than out of a contract. Example, it can bring a suit for wrongful infringement of trademark of patent. You understand what it is? See, it can sue others for enforcing rights arising otherwise than out of a contract. If you have a contract, you can raise a complaint against that particular person. If you don't have a contract, can you do that? You can't do that. That is what. So it can bring a suit for wrongful infringement. You wouldn't have done anything. It would not be your involvement at all. But though, what will happen? The case will turn to us. That is what? Infringement of trademark of patent. Okay? Your patent, because of your trademark, your patent, even though everything is there, you have got a goodwill also, what will happen? The court of law will not accept your points. The third one is right of third parties to sue the firm. What is the rights of third party? The rights of third parties against the firms are not affected by non-registration. It means that they can sue the firm or any of its partners. A partner of an unregistered firm cannot sue the firm or other partners for enforcing his rights under the partnership deed. However, his right to sue for the dissolution of the firm, or for the accounts of a dissolved firm, or for his share in the assets of the dissolved firm is not affected by non-registration. In short, non-registration does not affect the following rights. Can you understand? If you have not been registered, even a third party also can file a case against you, and they can get you sued. But if you have registered, even you can justify yourself over there, otherwise it won't be accepted at all. So these are the 3 points that we have if your firm is not being registered. In short, non-registration does not affect the following rights. What other rights? Suit not exceeding ₹100. If your partnership firm is less than more than ₹100, will not be accepted. So see, can you understand? If it is ₹100, for example, if a business, when you start a business, will you start a business for ₹100? No, isn't it? Sure, your partnership firm will worth at least minimum of 1 lakh or 2 lakh. So see, if it's only for less than ₹100, we can't do anything, isn't it? It's waste. It's of no use for us. The rights of a firm or a partners of a firm having no place of business in India. They should not have no place. They should not have a place for doing a business, it seems. That is the second one. See? So non-registration will not affect all these. See? Next one. The powers of an official assignee or receiver to release the property of an insolvent partner. The powers of an official assignee. The person who is going to be assigned officially, what he is going to do, or receiver, to realize the property of an insolvent partner. It means, insolvent means what? I already told you. Someone who is not able to pay back his debt. That is what he is called as an insolvent person, isn't it? So that is his third point. Fourth point is suit arising otherwise than out of contract as explained above. As I already told you, these 3 cases which we saw, that is the no rights to file suit against others, and then these 2, that is rights to sue for right arising, right of third parties to sue the firms. So it should not be raised according to these 3 suits. Okay. Next one, the rights of third parties against the firms or any of its partners. Then 6th point is sued by a partner for the dissolution of the firm, or for the accounts of a dissolved firm, or for a shares in the assets of a dissolved firm, as stated above. So these are the points. Okay. So the next topic that we have is dissolution of partnership. So what are the dissolution of partnership? So this is one of the most interesting topic in this chapter. So dissolution of partnership means what? So dissolving the partnership firm. You start a business by 3 or 4, for example. You want to just come out of your business. What will be your, like how you will come out of your business? That is what we are going to see here. Like how the dissolution will happen, and what and all the reasons, or for what and all situations will come out of the business. See, dissolution of the partnership is different from the dissolution of the partnership firm. Dissolution of partnership is different. Dissolution of partnership firm is different. You understand the term? See, dissolution of partnership firm means a complete partnership business is going to go for an end. Okay. Dissolution of partnership means only one particular partnership. Say A, B, C, D and E. 5 partners are there in a business. In that only one partner is going to go out of the business. So that is dissolution of partnership. You understand? So these are the 2 cases that we have. Dissolution of partnership, dissolution of partnership firm. Okay. So it is due to the fact that when the relation present between all the partners come to an end, it is known as dissolution of firm. Can you understand? See what I told you. So when everyone is going to dissolve in a partnership, A, B, C, D and E are going to dissolve, then it is a dissolution of partnership firm. But only one person is going to come out of the partnership, then that is dissolution of partnership. Okay. See, dissolution of firm. Dissolution of firm means dissolution of partnership. That is, on dissolution of firm, partnership business comes to an end. See, this is the point. On dissolution of the firm, partnership business comes to end. It will come for a complete end. That is what. So you're not going to have the partnership for no more. That is what. Its assets are realized and the creditors are paid off. Of course, whoever is going to, who are the creditors for the business, they will be getting off their money, everything, and then they will just shut down the business. That is what. The business cannot be continued after the dissolution of the partnership firm. For example, A, B, C are the partners in a business. If all the 3 partners decide to dissolve, then it is known as dissolution of the firm. You understand? All the 3 people are going to dissolve the firm. That is what dissolution of partnership. So it is not going to continue in future. But it is not this case in the case of a dissolution of a partnership. Let's see. Dissolution of partnership means the termination of the original partnership agreement. That is, partnership is dissolved by insolvency, retirement, expiry or completion of term of partnership. You able to understand? When you make an agreement, no, when you start a partnership, you will be mentioning one period of year, isn't it? Like say 5 years or 3 years, some term will be mentioned. So if that term is going to be accomplished, say 5 years is completed, then that is called as dissolution of partnership. You understand? So if you want, if still all the other partners also want to continue, then you can just again make an agreement and you can continue the business, no problem. If you want to just remove one or the other partner and then you want to continue, that also you can do. So these kind of dissolution of partnership will happen by few cases. See, insolvency. Insolvency means when one partner is not able to pay back his debt. So when he completely becomes zero, it means he is not even able to pay one single penny against his creditor. So that is insolvency. Okay, a person who is completely full of debt is not able to pay even a single penny towards his creditor. That is insolvency. Retirement means a person who has completed his retirement. After the age, there is a prescribed age for a partnership firm. So after that particular age, say 58 years, he will not be able to continue the partnership business. After that is called the retirement stage. So after that particular stage, say 60 years, he will not be able to continue the business. That is what the retirement. Expiry, when that particular agreement gets expired, say 5 years, 3 years, 2 years, after that the partnership goes for an end. Or completion of term of partnership, of course, that is what. So one particular work they have finished, but though they want to continue, you can even do it. Okay, the business will continue after dissolution of the partnership. For example, A, B, C are partners in a partnership firm. Okay, and if A retires, B and C can continue the business, which is known as dissolution of the partnership. As I told you, one can retire, one can be removed, and the other 2 also can run the business. That is what. Still, it will be existed. Okay, the circumstances leading to dissolution of partnership firm can be summarized by taking the first letters used in the terms of dissolution. See, this dissolution, D-I-S-S-O-L-U-T-I-O-N. So that has a meaning over here. D for death of a partner. We know in case if they have a partnership, they are into a partnership business, and when one partner is going to have a death, like in case if unfortunately is going to die because of accident or something or any other reason, so that is the first case, that is death of a partner. Next one, incapacity incapacity of the partner. He is not able to cope up with the other partners. He is having inefficiency, isn't it? So he is not able to understand anything, or he is not able to do any work properly. That is the incapacity of a partner. Next one, stipulated period of partnership completed in the case of particular partnership. So one particular period has been completed. So they have mentioned one particular period on the bond. Say the agreement states 5 years or 3 years. That period has been completed. That is for stipulated period. Next S, that is serious misconduct of a partner. One partner is going to cheat the other partner by some behavior, or when they come to know that he is done like this, there will be a misconduct of a partnership. Because of that also the partnership goes for an end. O means object is completed. So one particular reason they have formed the partnership, and that object has been accomplished. So at that particular time they will come out of the partnership. L for lunacy of a partner. Lunacy means going mad. Okay, he will not be out of his own mind. He will just go out of his control. So that is what lunacy is, going mad, mental, all that. Okay. So next one, U, that is unavoidable continuous loss. So not able to control the loss. They are not able to earn more profit, or they are not able to come out of that situation. That is unavoidable continuous loss. Next one, transfer of interest of the firm. Transfer of interest of the firm means they are transferring that partnership to some other person. If you want to transfer your partnership to some other person, can you continue the business? No. You have to make another agreement. You have to break up that agreement, and then you want to form another agreement, partnership agreement, isn't it, with the consent of other partners. That is transfer of interest. Next one, insolvency of a partner. A partner who is just not able to pay even a single penny towards the business, and if any liability in future, any liability is there, or in future any problem has to arise, at that time he is not able to even pay a single penny towards the business. That is insolvency of the partner. Next one, he is actually submerged with complete debt. Okay, that is what insolvency. O means objectionable, unlawful objective. What is objectionable, unlawful objective? It is not a lawful objective. If you have a kind of, that partnership is because of some, they have a intention of smuggling or some kind of unlawful activity. Okay, they are doing something like that. Then that is objectionable, unlawful object, which is against the law, economical law. Next one, N. Notice of dissolution by a partner. So if one partner is going to just come out of the business, he gives a notice to the other partner, then because of that also the partnership will go for an end. The fundamental differences between the dissolution of the partnership and dissolution of the firm is that when the partnership is dissolved, there is no other dissolution, but when the firm is dissolved, partnership too comes to an end. You understand? So it is very, very simple, isn't it? So this kind of concept you would have already known. Of course, if A, B, C and D are going to start a partnership firm, all the four, if they are going to just come out of the partnership, that is called as partnership firm. Of course, the partnership business will also go for an end. The partnership will also go for an end. But in a partnership, but this is not the case of the other case. See, dissolution of the firm is different. Dissolution of partnership is different, isn't it? But in dissolution of partnership, what will happen? Only the partners will go for an end, but the business will go on, and the other rest of the partners will continue the business. That is what is given here. The next topic that we have is dissolution of the partnership can take the following forms. Like how they can take, what are the different forms that we have, like how and all they can dissolve the firm. Okay, that is what we are going to see. See, changes in the existing profit sharing ratio. If they want to change the profit sharing ratio among the partners, for that they will go for dissolution. Admission of a partner. If they want to admit a new partner, they will go for dissolution. Retirement or death of a partner. This we have already seen. Insolvency of a partner also we have seen. Expiry of the term of partnership. Completion of specified venture. Venture is nothing but one particular task. They would have had one specified task. Based on the task, they will just come out of that. Once they finish the task, they will come out of the partnership business. Dissolution by agreement, of course. By agreement also they can dissolve. That is what the next one. See. These are the types. Dissolution of the firm without the order of the code. By this chart also you can write in your exams. When you're writing in the exam, if you make it like the chart and then you explain, it will be more easier for you when you explain your points. Okay, so you can just learn this chart. This is very, very important. What I have explained before, all the points are categorized over here. See the next one. Dissolution of the partnership firm is taken place in two ways. One is without the order of the court and by the order of the court. Without the order of the court means the court will not involve into the issue, okay? But by the order of the court means the court is going to involve and they are going to just give, dissolution of the partnership firm. That is what. So without the order of the court, let's see without the order of the court, like how it works. By agreement or mutual consent with all other partners, they all are going to give what? They're going to give an agreement, and then what they're going to do? They are going to dissolve the partnership. That is by the agreement. Next one, by insolvency of all the partners. It means all the partners are not able to pay back the debts. No, not even a single partner is able to pay back the money. So that particular stage also they will go for a end of the partnership. Without the court itself, they will decide this. When the objectives become illegal, when whatever they thought, immediately a government would have taken one law. So this business should not be done. So suddenly that business they can't continue, isn't it? At that particular stage, they will go for a dissolution. That is what? When the objective becomes illegal. It was legal before, but now it is illegal. So because of that, they are just coming out of the partnership. By notice of dissolution. By notice of dissolution means, so after giving the notice also, they can just come out of the partnership. That is what. In case a partnership, what will, when any partner gives in writing to all the other partners indicating his intention to dissolve the firm will be dissolved. So other see on certain contingencies also they can just, contingency means various situations, okay? Because of various reasons also they will just come out of the partnership. See, without the consent of the court, what are the various other situations that we have? See, dissolution of partnership itself may involve the dissolution of the firm unless parties agree to continue it. Otherwise, it will take place. What and all, how it will happen? On the expiry of a specified period of case of partnership for a fixed term. Next one, on the completion of a particular adventure. Same points are repeated again and again and again. See, on the death of a partner, on the retirement of a partner, on the insolvency of the partner. This all I have explained when I explained for these types, like how, what and all the reasons, like how they will, the partnership will go for an end, isn't it? So these are all points I have explained to you. So the next one is with the consent of the court, like how we can dissolution through court, like how the court will dissolve. See, the court may order dissolution of a firm at the suit of a partner in any of the following circumstances, like how the court will dissolve the firm. It is when a partner becomes insane. Insane means when he is not a proper person, he has become mad, he has become completely out of mind. That is insane, okay? That is one. Next, permanent incapacity of any partner. One person is completely not well, he is abnormal and he has got some big disease. He is not able to wake up from the bed, or he is completely not able to come back to the business. That kind of situation. Next one, misconduct of any partner. Of course, if someone is not behaving in a, he is not honest to other partners and he is doing some misconducts, then for that it will go, the court will go for the dissolution of partnership. Breach of agreement. So what is given in the agreement, if you're not going to follow, and if you're going to just come out of the, you're going to just overcome the agreement and you're going to do out of the agreement, then that is breaching of agreement, okay? You're not following the rules as per the agreement. So that is one of the reason. Next one, transfer of interest to third party. Without the consent of other partners, if you just immediately transfer the partnership to other person, in that case also it will go for, the court will order for a dissolution. Next one, continued loss. Of course, continuous loss, no partnership can run, isn't it? At that case also the court will justify for dissolution. Next one, when the court finds that it is just and equitable to dissolve the firm. At what case the court will find that it is just and equitable? One partner is doing some cheating to other partner, but it is not aware to the other partners, but though slowly he comes to know that this man is cheating towards him. So at that time when it has been proved to the court, then at that situation, what will the court say? The court say, fine, so if this is a case, he doesn't like this person, they both are not talking for a very long time, they don't have any kind of proper mutual understanding, so in that case the court will go for a dissolution. That is what the situation, okay? So these are the different types that we have, dissolution through court. So you have around 7 points, you have 7 dissolutions, 7 dissolution through court, we have 7 subtopics, okay? So this is one of the most important topic in this lesson. So please read the lesson line by line. So if you have any doubts in this lesson, you can come back to me on the live section, okay? So hope you all are safe and fine. Take care. Thank you, students.